The next case is West versus the City of Detroit. I'm sorry. Sorry, excuse me, go ahead.
Good morning, Your Honors. May it please the Court. Excuse me, Keith Bank appearing on behalf of the plaintiff appellant Faytreon Onee West. I know this Court has now had extensive briefing and now oral argument on the same exact issue, so I'm going to keep it brief and address something that I think wasn't stressed in the last argument. Is Rowland and this Court's jurisprudence now for the past 20 plus years has made it very clear that the start of judicial analysis starts with the plain language of a given statute. And in this case, the city has maintained this argument that MCL 691-1404 somehow requires service on an individual. It does not. The plain language of the statute uses may, a permissive modifier. In fact, the sentence says you may serve the individual notwithstanding anything else in the city charter. That creates a floor to service, not a ceiling. In fact, it gives the municipality freedom to accept other manners of service, to create an efficient network to deal with these issues. And that's what the city had done here. Until someone looked at the statute and said, hey, wait, we can attack how they're serving now. They set up this claim system that goes to the law department that litigants had been using for a really long time.
I had a question about that. Did it used to be the case that litigants would put Butch Hollowell's name or whoever was on the envelope? Like, how did lawyers just stop putting Butch's name on the envelopes in 2014 or whenever this problem?
I can tell you what my practice has been, and I've been doing this at my firm since 2006, doing the notices. And in light of Rowland, I examined the notice statute, and I also looked at the city's method. The city's website has always instructed you to send them to the claims department. And on the website, they have a claims form that tracks with MCL 691-1404. I attach it as an exhibit. They ask for the exact location. They ask for your injuries. They ask for the identity of any witnesses. So for them to characterize it as just submitting a claim, no, they have this form. They had the system set up. And I had addressed them to the law department for years, had never gotten an issue until this had sprung up. And the reason I was sending them to the claims department is, I understand this Court's jurisprudence, and I looked at the statute and I say, well, may be served on these individuals. And I'm like, okay, they may be served on these individuals, and my mistake. I should have, instead of taking it as a suggestion, I should have taken it as rote law. But I was like, okay, well, no, the city has set up this other one. The statute set up the system. The statute doesn't make it mandatory. I can follow the city system, perhaps expedite it instead of sending it to Mayor Duggan or Janice Winfrey, where it then goes through another process where it just ends up in the same exact space. And I know this question was asked in the Wigfall argument, but whether I submit them to Melvin Bush Hollowell or I submit them to the law department, they're handled the exact same way. In fact, after this case, I started sending them to Melvin Bush Hollowell. And same exact thing happens. You send in the notice. 3 to 4 months later, you get a letter from the investigator asking for more information, and then you go from there. There's no evidence that this would have been handled. And I think it's a little ironic that had I walked into the office with my envelope, the address of the city law department, and say, I'm here to serve the city attorney, and given his secretary that notice personally, would we have a problem here? And I don't know. I don't think so. And I think that's, the step back we have to take in this case is...
In that instance, you probably would have fallen under MCL 619.25 by giving to someone substantially the same duties as the city attorney, irrespective of job title.
Or someone in charge of the office. I think that as well as good personal service on an individual.
Someone in charge of the office with substantially the same duties, exactly.
Yeah. Yes.
Was the law department an agent authorized by law under 1930?
I would argue yes.
All right, tell me why.
Now, I mean, I don't know if I would call it an agent or just the city, the law, or the office of the city attorney. I don't know if that's an agent.
An agent of the corporation council.
Well,
Or you see it as one and the same?
I see it as one and the same. I don't know if you're talking about specific individuals within the City of Detroit Law Department. I don't know. Then I think we might be talking about delegation, but the City of Detroit Law Department is what Melvin Butch Hollowell is the head of. So I don't know if there's an agency relationship there. I would say that is his agency. I mean, he is the head of that particular department. That is his corporation, I guess you could say, if you were looking at it from that perspective.
So these provisions, though, in statute that define how you serve against a governmental agency, it refers to an officer or a person in charge of the office. When you just send it to the law department, are you sending it to the person in charge of the office? Or are you sending it to an officer with the same duties as the city attorney?
I would say officer with the same duties.
How do you know?
That's who the city is designated, as to receive these claims. They've delegated the claims department. So whoever is processing these in the claims department is the one who has been delegated this authority. If there are no other questions, I will reserve time for rebuttal.
You may do that.
Thank you.
Good morning. May it please the court, Sherry White on behalf of the City of Detroit. I just first of all like to sum up very quickly. The city is asking that the court either deny leave or peremptorily affirm the Court of Appeals. The Court of Appeals was correct in this case, and I'm going to sum it up as quickly as I can. The notice failed to comply with the statute as written, as this court required in Rowland. It was not served on any individual. That's the key word here, individual. And in this case, no individual was served at all, much less any of the three that can lawfully be served with process on behalf of the city. So in response to actually the second question that the court posed to us in this case, this notice did not comply under any construction of the statute, strict, substantial, in any way. The legislature wrote the statute the way it's written. This court has held that it must be enforced as written. And Justice Markman, in reference to a discussion you had with Ms. Fagans, the statute, I believe, would require that the notice be addressed to, for example, Butch Hollowell or the Corporation Counsel, because it does say any individual, either personally or by certified mail. So the word individual applies to either form of service that's permitted here.
Do you represent the city of Detroit right now? Here in this court, do you represent the city of Detroit?
Yes.
How do I know that? You're not.
I represent the city of Detroit in this lawsuit. I'm not authorized to accept anything, and I do not accept anything. The law sets forth because of.
So you represent the city of Detroit for purposes
bureaucracy.
of arguing. You represent the city of Detroit for purposes of arguing in this court, but not for purposes of receiving any service?
That's correct, because I'm not authorized to do that.
Even though you're their lawyer?
I'm their lawyer because the city charter provides how lawsuits are handled on behalf of the city. This statute provides how these notices are to be served, and there are only the three individuals that are authorized to accept service. And there are very good reasons for that. In an organization, there has to be some sort of process that's spelled out clearly and concisely and plainly like it is here.
Why was this an argument the city of Detroit never made until whatever it was? Like, we started seeing these cases just recently. So was this like you guys had a staff meeting and someone thought, we have a new argument?
Rowland has been the law since 2007. The city of Detroit has won 9 cases in the Court of Appeals on this issue since Rosie Withers in 2016.
But so that's what happened, but why did it take until 2016 for you all to make this argument? It sounds like before then, people were sending their notices to the law department, the city's lawyer, the city attorney. We've been litigating that issue since the first case that I'm aware of is that we prevailed in is the Rosie Withers in 2016. So do you know who thought of that theory in 2016? How did that?
Well, it was raised by our trial attorney in the motion. I handled it on appeal.
Counsel, can I follow up on a point that Justice Zara made earlier? He was talking about, I believe, the provision in the city charter which says that all claims of whatever kind against the city shall be first submitted to and reviewed by the law department. Let me add to that, if I might, a fairly ancient principle of agency law, which says that in the law of agency, it's a fundamental principle that every delegation of power carries with it authority to do all things which are reasonably necessary or proper to efficiently carry into effect the power conferred. And that's Emery versus Ford, a 1926 decision of this court. Why don't those two provisions together suggest that there is effectively an agency relationship here, and that relationship is broad enough to allow the agent, namely the law department, to accept the notices that are a prelude to the claim against the city of Detroit?
Justice Markman, the claims process that the city has is far broader than highway defect cases. There are all sorts of claims.
No, I understand that, but this is
fault
all claims against
that is the broader claims process.
Mm-hmm.
The process for handling claims under the highway exception is set forth in MCL 691.1404.
But we also have state law that says that there can be established agency relationships here, and I'm just asking why there hasn't been an agency relationship that's been effectively created by this provision and the general proposition of agency law that I just suggested to you.
Because the mayor, the city clerk, or the city attorney, none of them have delegated that authority to anybody. That's not an issue here. There has been no such delegation.
Your website says that the law department represents the city of Detroit in all legal matters. So it sounds like they actually have delegated it to the law department.
More important, an ordinance of your city. An ordinance says the law department shall handle these claims. Why isn't that an agency created by law? Is now your ordinance law? It's passed through the city council and signed by the mayor, just like any other law.
An ordinance is law, yes, but as I stated, the claims process is a much broader process than what we're dealing with here. What we're dealing with here is controlled by the state statute, 691.1404,
Okay,
which
go
is
ahead.
to be enforced as written.
As written, it says it may be served on an individual. It shall be served on a governmental entity. The governmental entity is Detroit. Detroit's ordinance creates an agency that permits, pursuant to 600.1930, the agent authorized by law to accept on behalf of the governmental agency. Where am I not being loyal to the text of the law?
Again, looking at 691.1404.2, there's nothing that permits any of the designated individuals to delegate that authority. There are other statutes that do. For example, MCL 15.236 paren 1, which is the FOIA coordinator statute. But there is no such provision in the statute that we're dealing with here.
Counsel, what do you
And even
make
if there
of-
were, there has been no such delegation.
Justice R, I think alluded to some of the language in 1404, and you're asking us to closely read the statute, and I want to ask you the same question I asked your colleague. Why should I not pay attention to shall serve a notice on the governmental agency in 1404 subsection 1, and also not focus on the fact that when it talks about an individual, when you've recited that, you've sort of conveniently left out the word may. Shouldn't I pay attention to what the legislature is telling me when they say you shall serve a notice on the governmental agency? The notice may be served in this way? Shouldn't that matter, or do those words just not matter to us?
Those two subsections taken together, Your Honor, 691.1404 paren 1 says that the injured person shall serve a notice on the governmental agency of the occurrence of the injury and the defect. Then subsection 2 goes on to say the notice may be served on any individual, either personally or by certified mail, return receipt requested, who may lawfully be served with civil process directed against the governmental agency.
Keep reading.
I don't believe
Keep reading. What's after that?
Anything to the contrary in the charter of any municipal corporation notwithstanding.
Okay. I guess then it has to be the charter as opposed to an ordinance?
Again, I don't believe any broad provisions for a claims process in the charter abrogates the requirements of this statute.
And do we read that last sentence as saying that if the charter says you shall only serve the mayor, that's null and void because it's mayor, city clerk, and city attorney? Or do we read that to say, at a minimum, you can serve the mayor, city clerk, and city attorney, but if the charter provides more, that's available too?
Well, reading the two subsections together,
You're going back to 1 and 2.
Our position is that you must serve one of those three individuals, not all three, but one of those three individuals. I think that's the implication of that first may in that sense. Plaintiff takes the position that that first may opens up the entire door basically, and they go so far as to say that if there isn't compliance, then the burden would fall to the claimant to establish that the municipality accepted notice of claim within 120 days.
I just want to make sure.
That's so far from compliance.
I want to make sure I understand your argument. When you read 1404.1 and 2 together, the first may in 1402 is shall. The only way to read 1 and 2 together is, this is your argument, I just want to make sure I understand it, is that when you read 1404.1 and 1404.2 together, the use of the word may in 1402, the first time, must be read as a shall. Is that a fair statement of your argument?
I think when you put the two sections together, it indicates a notice must be served within 120 days, and it may be served on any one of those three individuals, but there's no provision for service on anybody else. So it has to be served on one of those three, not all three, but one of those three.
Well, then we have other statutes that broaden that. It doesn't have to be served on one of those three. It can be served on an officer in charge of the office. It can be served on someone with substantially the same duties. It can be served on an agent authorized by law.
Well, that's the rules regarding service of process, again, are entirely different, where it does provide that in any case, service may be made by serving a summons and a copy of the complaint on a person in charge of the office of an officer on whom service may be made. That's from MCR 2.105. That's service of process. Again, there's no such provision written into 691.1401 subsection 2.
Are there any further
So
questions?
that I don't think the the rules pertaining to service of process are applicable here, because there's no such broader rule written in there.
I don't believe there are any further questions. Do you have anything else you want to tell us? Or?
And just very briefly, going back to a question that Justice Viviano asked asked Ms. Fagans about actual notice. Again, MCL 691.1404 paren 2 makes no such provision for that. So
What's interesting to me is it sends us to the rules and statutes about service of process, which I understand to be the service of the complaint, the summons, the very important documents that give the court jurisdiction to hear the case in the first place. And with respect to those important documents, our rules are very clear that if the city has actual notice, that the case will not be dismissed because of some technical deficiency with the service. So why is it that you believe that we shouldn't apply that same sort of framework as it relates to a pre-suit notice?
because Roland says otherwise. It must be enforced as
But
written.
Roland's not talking about service of process. Roland talks about, I think, the timing of notice. We've had other cases that talk about the content of the notice. My understanding is you're not challenging either the content or the timing of the notice, correct? Notice was received on time, had everything you needed, even went to the place you would have sent it anyways.
It all has to be complied with.
It all has to be complied with. Okay.
Thank you very much, counsel.
Thank you.
The city of Detroit argues that the important word in the statute is individual. The important word is may. They're the ones who need a judicial construction of the statute to turn that may into a shall. And they have never presented a compelling argument as to why this court should present or should interpret that may as a shall. The Court of Appeals attempted to get over that difficulty by using a frustrates the purpose of the statute standard. One, the frustrates the purpose standard has never been adopted by this court. It hasn't been adopted in the last 20 years that this court has been reviewing the statutory language. Second, the Court of Appeals doesn't articulate how interpreting that may as permissive frustrates the purpose of the statute. The purpose of the statute was articulated in the Plunkett case, and I believe Judge Zara was on the panel that authored the Plunkett decision. And that decision set forth the purpose of the statute pretty concisely. It says, the purpose of the statute is to give notice in a timely fashion so that the municipality can investigate the defect, and investigate the incident, and remedy the defect. I don't see how a manner of service frustrates or plays any role in that purpose. So long as the city receives the notice.
When we take Plunkett and Roland together, though, can we not say that Roland talks about the procedural requirements require exact compliance, the substantive requirements of notice, which say notice can be given any way? There's a broader range of how you can make that notice. That's what Plunkett stands for. At least when I signed on to that PC opinion, that's what it stood for.
I'm sorry. I agree wholeheartedly. I was just using it for the proposition as to the general purpose of the notice statute.
But there's a difference between the procedural requirements and the substantive notice that's required. Plunkett related to the substantive. How much detail do you have to provide to give notice as to where and how this happened versus it must be served in X number of days and on Y person?
Oh, I agree. I agree, but I still think it's good for the general even though you're dealing with the content in Plunkett, I think it's still good for just looking at the global purpose of the notice statute in general, both procedurally and substantively. It sets forth a framework to timely provide notice so that the municipality can investigate and remedy a particular defect. So although Plunkett does specifically talk about the content of a notice, I still think it makes a good statement as to the overall purpose, both content and procedurally, of the notice statute.
Does that run afoul of Roland?
Excuse me?
Supreme Court is Roland, right?
No, I think it's still consistent with Roland because Roland, 120 days is 120 days. And so timeliness is defined by that 120 days. So I don't think
Okay.
that, what I'm saying
And
is.
may,
is-
and may means may.
Yes,
Okay.
thank you.
Thank you, counsel. The case will be submitted.